We spent the morning talking about how we're defining privacy harms and the boundaries around what is a privacy harm and is not a privacy harm in this new data-driven world. And since we figured all that out, we're going to talk about how we measure those harms and how we account for those harms in risk assessment in this panel. So we're just going to go down the line for presenters. Ryan's going to start us off.
Okay, I think this is on. Is this on? Yes. Great. I'm going to say the same thing that I always say whenever I come here, which is that I love coming to Silicon Flatirons. I just think it's a fabulous place. I mean, it's a place where you can bring together all kinds of fascinating people, top academics, practitioners, government, reporters, and so forth. And they just do an astoundingly good job of teeing up the issues and, you know, apart from me selecting really great people to participate. So once again, you know, congratulations to Phil and Paul and everyone and Scott and Harry and everyone for putting this on. It's just fabulous. So I thought about privacy harm in the past, and I had this effort a couple years ago to sort of try to figure out what privacy harm was. And in trying to get as specific as possible about the nature of privacy harm, I ended up just kind of sidestepping any conversation about risk, right? So I said something along the lines of, look, you know, a risk of harm, of privacy harm is no more privacy harm than like a chance of ice cream is ice cream. You know what I mean? Like it's just, they're just different things. Like, and if you're trying to figure out what privacy harm is, you don't necessarily want to have a long sidebar about the risks. So, you know, in this presentation, I want to talk very briefly at a pretty high level about how I think one would go about assessing risk. And I think that the way to do it is actually really to slice it on the basis of people. So you heard from Paul earlier about Dan's taxonomy, his enormously influential taxonomy, which slices privacy harms based on a bunch of activities, right? He surfaces these problems, and it's basically activity-driven. But I think in risk assessment, the thing you want to think about is what are the capabilities and the incentives of the relative players? And they may be different from one another. And as a consequence, you might want to focus more on one than the other. You might want to provide a different remedy to one than the other. And so, you know, in trying to figure out both how to assess what the risk is going to be and also to address that risk, I think that the role of people is really important. And so when I, you know, have taught privacy law or talked about privacy law with students in the past, I end up slicing it invariably along the lines of there's peer-to-peer issues where we invade one another's privacy, right? There are privacy harms to citizens, which we heard about quite a bit this morning. And then there are, of course, privacy harms to consumers, so as by corporations. And that's one way to sort of slice it up and to sort of figure out what we're talking about. And I guess my question today is, should we worry similarly about all three? Not necessarily should we worry as much, but a little bit of that as well. But should we worry similarly about all three? So what characterizes peer harm? Well, you know, the internet makes it possible for individuals or groups to realize, you know, some pretty terrible privacy harms, shaming, revenge porn, et cetera. But really, certain factors really have to combine for this to happen. And others, like norms and fear of laws, need to be absent. And not often, but not necessarily always, the victims and perpetrators have similar access to resources, right? They're relatively well positioned. Now, I understand that it's more complicated than that. So in domestic violence, for instance, or in other instances, there may be a relatively big power differential between the two. But, you know, almost by definition, peer harms are going to be, you know, victims and perpetrators on a roughly even playing field. And so, and also, of course, people tend to be disproportionately targeted sometimes, and so that's a big difference. So then we have corporations. Most corporations have far greater access to resources than individuals. They have strong and consistent economic motivations to deploy those resources and to do so in ways that are systematic. And their motivation, I think it's really important to note, is that it's constant. It's always the same motivation. Whether your data is in this company's hands or this company's hands, they're both going to, at base, have an economic motivation at heart. It's not mercurial. They're responsive to market pressures, assuming kind of two big ifs, that the consumers understand the firm's practices, the company's practices, and that they actually have real choices to effectuate. And corporations are also responsive to, but of course, simultaneously influence government structures. So finally, government, right? So we heard from President Obama's speech this morning that we should have special reason to be concerned about observation and surveillance by government. Why is that? Well, governments have vastly more access to resources than citizens and probably somewhat greater access than individual corporations. They have strong but mixed motivation to deploy those resources. Importantly, government motivations are inconstant. They can vary widely depending on a host of factors, including who happens to be in charge, what the political zeitgeist might be, economics, current events, and so forth. And they also, again, and you heard the president say this morning, they have a monopoly on coercion, right? What they know or think that they know has physical ramifications. One instance of harm that we might have thought about, and this came out in conversation with Julia Angwin, was basically that you could maybe not be able to travel to the United States because some inscrutable algorithm has popped your name up on the chart, right? So on the no-fly list. And that's very different, I think, in a lot of ways. And then, of course, there are hybrid categories, and there are there's other instances. There are these sort of loosely affiliated criminal organizations and so forth. And then it'd be remiss if you're starting to map out this space in an almost game theoretical way. You'd be remiss not to talk about the interactions. And you heard Eld Felton talk about this a little bit in a previous panel. The idea that maybe the fact of corporate surveillance or corporate observation may make it possible to do more surveillance by the government, how these things relate to each other. How indeed the whole existence of the data broker industry is in some ways traceable back to the decision by the government to collect this stuff in the first place and to make it public. Those were the building blocks of the whole data broker industry. So there's an interrelation between the two. Each of the players act upon each other in complex ways by voting and buying and funding and talking and taxing and punishing, right? There's all these different ways that they work with each other and affect one another. So all I've really done here is do what a lot of academics like to do, which is basically make the space more complicated, right? But I want to sort of say what I think what we might sort of learn from the fact that the players matter and they have differing capacities and motivations. Well, I think that basically law and policy should reflect that to a greater degree than it does already, right? So the idea is that in fashioning remedies, in fashioning rules, the law should be cognizant of who has the capacity to do the most harm, right? And so, for instance, I've always thought it was very strange that with respect to the Privacy Act, and so this is the act that actually, under certain circumstances, explains when the government may give information, the federal government may give information it knows about you to a third party, may share information and so forth. I've always thought it was sort of ludicrous to suppose that the government needs to show that the plaintiff needs to show actual harm, in order to recover, and even the idea that the Privacy Act would be limited to economic harms. There's a real disconnect there. You see why that would be, right? So on the one hand, it's like we ought to maybe presume that the government's being harmful when it's doing these things. The statute, by its language, the Privacy Act appears to presume that, right? But courts have repeatedly, right, in Chow and later on in the FAA Cooper case, actually required the plaintiff not to show that there's actual harm, right, but tangible harm, but also limited to be economic. And that is very strange, given the fact that the motivations of the government are not ultimately around economic harm, right? And so there's a disconnect there, I think, versus, perhaps another statute like the Computer Fraud and Abuse Act, which, if anything, lowers that bar to there being a lot of harm, right? So you see it being deployed, and arguably some of the sections do and some of the sections don't, but a very aggressive prosecutor is able to bring, and we've seen this, and a lot of discussion about this, bring a really aggressive criminal case against somebody who exceeds their authorized authority or goes and uses a website without violating its terms of service with very little in the way of minimal harm showing. So, but it's strange. It's strange to talk about those things differently, and it's especially strange actually to treat all these different parties together. Another example would be the Electronic Communications Privacy Act, the way that it basically applies in a sense equally or especially to individuals, but if anything, it has carve-outs for the government and carve-outs for corporations that it doesn't have for individuals. So my point is just these are a couple examples of places where I think we could be more thoughtful about our law and policy that was recognizing the respective capacities and motivations of government, corporations, and individuals. And so the way that, in my view, this plugs into the idea of risk assessment is, again, risk is, and I hope we'll hear from the other panelists, risk is largely trying to guess what people are going to do. And what they can do and what they're motivated to do seems to me the best way to do that. So again, thank you very much for having me, and I hope that we have a nice discussion.
Nicely timed. Devin?
I'm going to take some of your time.
Yeah, you got it.
Go for it.
I don't know, hopefully not. Thank you very much. I did slides. I may have been the only one. Somebody likes it. I'm going to take you down a little bit of a rabbit hole into the world of HIPAA, the Health Insurance Portability and Accountability Act, which is the health privacy law that governs us federally and is a law that I think about in my daily job. But it's a little arcane, and I imagine for a number of you, it's not very familiar, so I thought slides would help. The second thing is, don't despair if you hate HIPAA. I think you'll still find this presentation interesting, because I think it does raise questions about sort of how do you manage the risk of harm? How does a current legal regime try to manage the risk of harm with the type of data that I think everyone generally agrees is very sensitive, although individuals will differ themselves as to how sensitive they think that their health data is, and that maybe there might be a way to extrapolate to other circumstances. So I am writing a paper with my co-author, Alice Leiter, who works with me at CDT. We are trying to get HIPAA to regulate uses of data, particularly what are sometimes called secondary uses of data analytics, to improve the healthcare system, which we need a lot in America. If you don't do health at all, you might be blind to the notion that, or unaware of just how poor quality our healthcare is in the US, and yet we pay more for it than anybody else. We need to be leveraging data more and not less. But how do you do that in a regime where people are sensitive about their health data and its reuse? So we're going to be talking specifically about some reuse provisions in HIPAA. In some cases, one could argue that parts of HIPAA are risk-based, but in an example that I'm going to talk about today, there's one where it doesn't, and it really does have an impact on our ability to learn more from the data that gets generated every day in routine clinical encounters in doctors' offices and hospitals and with health plans. So ideally, I'd like to get some sense of what types of activities we think do raise the potential and risk for harm. And then, potentially, if there's time in the paper and we have time when we're writing it, think about how that model could be extrapolated to other circumstances involving health data. I doubt we'll have time for that today. So what is a harm? And I was glad that Ryan went first, and certainly in terms of his previous work on privacy harms, there's the subjective and the objective. Clearly, some of these are more easily measured than others, a point that's been brought up a lot today. But we have another harm that we think about in healthcare that's pretty critical, and in fact, in some respects, trumps the others. And that is the loss of trust by patients in the healthcare system, in the system's ability to keep their data confidential. And some might say that that's sort of akin to embarrassment or reputational harm. Sometimes it's more about, it's just nobody's damn business but mine, what's going on with me personally, whether that's something I should be ashamed about or not. I don't care. It's my health data, and I want it to be private. I want it to be kept confidential. But we do know, in terms of how do you measure the kind of harm that's about loss of trust, this is probably another iteration of CHILL. What we do know from survey data, and that's the only way that I've ever seen this ever measured, is that people will say in surveys confidentially that about 1 in between 6 and 8 of them, there have been a number of these studies that have been done, they practice what are called privacy protective behaviors if they don't have confidence about how their health data is going to be handled. They don't seek care, or they try to hide information, or they lie about something that's going on with them because they're worried about what's going to happen to that data down the road. Now, 1 out of 6, 1 out of 7, 1 out of 8, that's not the majority of the population. But when you have a healthcare system that ideally should work for everybody, it's significant when those people are essentially opting themselves out, and they may not be seeking care for a condition that in fact impacts all of us, potentially, mental health care. a transmittable disease. So this is pretty important, and so those are sort of the harms that have traditionally been focused on in the healthcare space, and that some of the legal regimes have been built around trying to minimize. So brief HIPAA primer. What is HIPAA? There's no privacy in any of those P's, but it does have a privacy rule. Most of it's actually in regulation. There's very little in the statutory text. It is a sectoral law. It's not a data protection law. It does not protect all health data in any commercial or other context. HIPAA only applies to covered entities. Your doctor, if they're billing electronically, if they're still sending paper bills, they're probably not covered. The hospital that you go to and your health plan and something called a healthcare clearinghouse. I've never met a single person who ever worked in a clearinghouse, but they are covered by HIPAA. And then they're contractors. So if they hire somebody to do something for them, like to bill the insurance company, doctors do this frequently, they don't want to be bothered with it, that contractor is going to get health data, and those are considered to be business associates, and they're covered by the law as well. So that's HIPAA in a nutshell. How does HIPAA regulate health data risk? In a number of ways. So it's not blind to risk. I'm going to show you one example where it feels fairly blind to risk, or it's now outdated and not blind to risk anymore. HIPAA applies only to individually identifiable health information. And it strongly encourages the use of either less identifiable or what's called de-identified data. When you de-identify it to HIPAA standards, it's not subject to any regulation whatsoever. And then it has this sort of, I call it the close cousin. It's called a limited data set. It still has some identifiers in it. And so it's subject to some additional protections, but it's still regulated less stringently. The other way that HIPAA regulates sort of based on risk is to allow most what are considered to be routine uses of healthcare system entities without needing to get express consent or even general consent from the patient. That HIPAA form that you sign in a doctor's office is not a consent. It's just an acknowledgement that you've read the notice of privacy practices. Many people misunderstand that. A healthcare entity can use your information or disclose it for what are called treatment, payment, or healthcare operations, bunch of administrative tasks with healthcare without having to ask you about it first. But then they say you have to get the patient's authorization for the non-routine tasks, or the tasks that might be considered to be more extraordinary, or maybe not as expected by patients. Or maybe it's really just a historical antecedent, for example, that research requires authorization. And then these business associates that I talked about, these contractors, they have to sign agreements agreeing to protect the data. So that's another way that HIPAA tries to manage risk. Here's where I start to paint the use case that seems to me very non-risk. It's non-risk based in terms of how it regulates health data use. So here are two types of healthcare operations. Remember, they're supposed to be routine. You don't need consent in order to do them. You can conduct quality assessment improvement activities. You can evaluate patient outcomes. You can develop clinical guidelines. You can do population health, as long as you're not trying to contribute to generalizable knowledge. If you're trying to contribute to generalizable knowledge, that's research. Research requires authorization. Research requires approval by an ethics board. You can waive authorization under some circumstances, but you have to meet a test in order to do so. Generally, the way that has been interpreted is that as long as you do the study and only use the results internally, not the data internally, but the results of what you learn, well, that's operations. But if you intend to let everybody else in the healthcare community know what you learned, well, that's research. Same study, same data, same people. They will be treated as operations and routine as long as you don't share what you learned. And then we'll treat it as research if you want to share what you learn. And this does not make sense, both from a risk standpoint or in an environment where we're actually trying to learn more from health data. So my colleague Alice and I have already done a little bit of writing to point out this paradox. Now we need to take the step of saying, all right, that's not based on risk. How should we orient the rules so that they are more risk-based, so that we regulate more stringently those types of activities with data that raise more risk for patients, and risk being risk of harm, risk that we're going to undermine that trust that we need people to have in the healthcare system. And what are those, it should not be based on whether you intend to share the results. And again, keep in mind that when I say share the results, I'm not talking about sharing the data. I'm talking about sharing what you learned, right? That this particular infection control procedure, for example, works better. Or if you administer the drug in the morning versus in the evening, it works better in the following populations, right? Why would we ever be worried about releasing that result from a privacy standpoint? I mean, certainly you can see, depending on how much additional data points are part of a result, there might actually be some risk related to, publicizing the outcome. But generally, I think we should be thinking more about how we do that analytics and what is riskier about analytics in certain, that we do in certain ways versus others, and reorient the rules around that. So, some of the factors that may increase or decrease the risk or potential for harm, identifiability, certainly that's been, something that's already embedded within the regulations, but questions have been raised about just how much that protects. Professor Ohm, for example, has raised some really important questions about anonymization, lack of transparency to patients, information moving out of the covered entity, and does it matter, for example, if it's physically moved out, or should we be focusing on the loss of decision-making control? Sensitivity of the data. Health data is all sensitive. HIPAA treats it all like it's equally sensitive, but frankly, state law actually typically layers on additional protections for more certain sensitive data categories, and there are additional federal laws around substance abuse treatment data. What if the information is being shared with an entity that itself is not subject to any privacy laws? Does that make a difference? What about indefinite or indeterminate retention periods? Should that be a factor? And I think, in our paper, we may not have enough time to sort of tease out all of these activities, but I was hoping that in part my attendance at this conference would help give me more ideas for what constitutes risk in healthcare. And I'm almost out of time. The only example I had in the last slide is I work on a federal advisory committee, and we took up this issue actually in some comments for an advance notice of proposed rulemaking. And we came to the conclusion essentially that this paradox that existed in the rule made no sense. And that really you ought to be focusing on what we came to consensus around was decision-making control. When that leaves the entity that the patient typically trusts, which so far in survey data, people trust their doctors. They don't necessarily trust their health plans. They trust their doctors. How can we leverage that, right? And if the doctor loses control over decisions about how that data is used, is that what makes a difference? We said as an advisory committee, we thought that it did, and that ought to be sort of where you draw the line between regulating more robustly and not. But then when we started to come up with, we were just not comfortable with calling all quality improvement non-research, right? We were like, where should that line be drawn? And we left open the work that I hope to do with my colleague, and that I'd like to be more informed of by all of you and other sectors who are grappling with this. Thank you.
Thank you, Devin. Chris, our last presenter.
Thanks very much, and I want to join the others in thanking Paul, but I have a special reason for thanking you, Paul. I've always wanted to speak in a building called the Wolf Law Building. In fact, I may move in. So I wear a number of privacy hats. Some of you may know me in my role as the founder and co-chair of the Future of Privacy Forum, for which Omer Tenney is a senior fellow. And I also help to lead the Coalition for Privacy and Free Trade. But my day job is as head of the privacy practice at Hogan Lovells, and it won't surprise you to hear that in that job as a privacy lawyer, I am advising businesses that collect and use and share and retain personal data. And my job is to help them with the risk management, and in particular that means avoiding lawsuits and avoiding regulatory enforcement by the FTC and increasingly by state attorney generals. So risk management is, as you might expect, advice on how to comply with the law. But I also really view my role, and a lot of us in this field do, view our roles as privacy counselors, because it's much more than just risk management and making sure that a particular law isn't violated, especially since we don't have a comprehensive privacy law in the United States. Much of the privacy legal landscape is created by sectoral laws or geographic laws. My clients expect me to help them do more than just comply with the law and avoid the risks of legal violations. So I'm called upon by them to help them respect consumer privacy beyond the minimum legal requirements. This is kind of a change from what it used to be. I've been in this particular area of the law since about 1998, which makes me one of the earliest people to practice privacy law. When my Y2K practice didn't pan out after the year 2000, I really focused intently on it and was joined by others. But in the early days, most businesses would come to me, or I'd go to them and say, you need a privacy lawyer, you don't know it, but you do. And they say, well, tell me the minimum I need to do to obey the law. Well, I think we've gone a long way from that particular situation, because businesses understand that privacy is more than a legal obligation. It's an obligation that goes fundamentally to consumer trust and to corporate reputation, and we see that every single day and in the headlines that we've talked about today. So clients understand that when they develop products and services and when they innovate, they've got to follow kind of a corporate Hippocratic oath to do no harm. But what is harm? They know that with the definition of unfairness in consumer protection law not entirely clear, as we heard a little bit earlier today, and with the fact that lawmakers are focused on privacy as never before, it really wasn't part of their vocabulary until pretty recently, they've got to be on guard against practices that not only violate existing laws but might cause new laws to be passed, as well as regulators to say, well, that probably ought to be illegal, so we're going to start an enforcement action. So it's not surprising that when businesses set out to evaluate what constitutes harm that they should avoid inflicting on their customers, the law is only a starting point. And of course, my clients understand, or I tell them, that when they make a promise in a privacy policy or an advertisement, they've got to do what they say. So many of the FTC enforcement actions are against companies that say they're going to do one thing but do something else. And they also understand that they need to respect consumer choice. And they know, or I tell them, that the common law of consent decrees that we heard about and that Woody has written about, and enforcement actions that emanate from the FTC and state attorney generals do create a set of rules that they need to be aware of. And that there are, in fact, statutes, and Ryan mentioned a couple of them in his presentation, that prescribe conduct and remedies, especially, and Devin as well mentioned the sectoral regulation in health, and it also exists in finance. But respecting consumer choice and complying with the large and an increasing handful of privacy statutes really doesn't account for all the harms that consumers care about, or that society should care about. And so I'm here to say that the law is the beginning of the analysis and not the end of the inquiry as to what is privacy harm, how do we measure it, and how do we protect against it. And for too long, when discussing harm, the focus has been on notice and consent, and harm has been equated with collecting personal information without providing notice or without obtaining consent, or using the data outside the scope of consent. So look, I'm not saying that notice and consent are outmoded. There was some kerfuffle this week, for those of you who subscribe to the IAPP privacy perspectives, between Ontario Privacy Commissioner Ann Cavoukian and Professor Victor Meyer-Schoenberger about what's the role of notice and consent. It absolutely has a role, but it has a very complicated role, and perhaps doesn't have a role, don't tell Commissioner Cavoukian I said that, when it comes to the Internet of Things, where there might not be an opportunity to see a notice and make a choice. And it's really difficult in the world of big data and data brokers. And so a focus on notice and consent and collection is inevitably going to miss fundamental privacy harms. Relying on collection, notice, and choice is, in my view, an under-inclusive way to measure and prevent harm. Restrictions on collection are not the only and certainly not the best way to prevent privacy harms. And in addition, undue restrictions on collection can be shown to threaten innovation. I would also say that a technical violation of a written privacy policy that's seized on by a class action lawyer does not necessarily mean there has been privacy harm. I've seen too many attempted class actions that seize on those technical violations where there truly has been no harm of the sort that most consumers care about, and the courts have recognized that when they find, as a matter of Article 3 standing, case in ripeness, injury in fact, that these are not the things that courts should be dealing with. But that doesn't mean they aren't things that companies should care about or that consumers might have a concern about. And likewise, a technical violation of a statute doesn't necessarily mean that there's been a harm that consumers care about. And I'll point you to cases under the Video Privacy Protection Act for examples of that. So the reliance on the current legal boundaries to establish the meaning of privacy harm means that some legal harms are overblown, but more importantly, many harms are missed. And the harms that need to be considered are both tangible and intangible. And we've talked a bit about that today. And tangible harms are, of course, things like financial loss, identity theft, physical threats or injuries, and unlawful discrimination. Intangible harms are the harms that are often missed by the law. And those are things like embarrassment or social stigma. There's a wide range of potential harm that stems from the use of information that is true, but harmful to someone's reputation and not covered by the law. And the example that resonates with me is one of a teenage boy or girl that might be researching the internet for information about sexual orientation using a family computer, with the result that later on information, say a targeted ad, is pushed to the parent owning the computer, essentially outing the teenager, which is probably not the way that teenager wanted to tell his or her parent. And when I was growing up, I had friends whose parents literally threw them out of the house when they found out they were gay. And hopefully such instances in this current environment are waning, but you get the point about the perils of unwanted or inadvertent disclosure or the suggestion of intimate information. And that resulting emotional harm that comes from that is not one that is necessarily subject to legal remedies, because it doesn't fit neatly into a privacy harm framework that's based on broken promises or statutory injuries. To fully inventory the intangible harms, from the outing example to the much-mentioned creepiness, isn't easy. And I would say it's not subject to legal definition. So I'm not here suggesting that we try to inventory a new category of harms and make them all illegal. But the fact that lawmakers or regulators aren't able to set boundaries doesn't mean that businesses don't care and won't undertake on their own to avoid harm while they continue to innovate. So when I work with my clients in considering appropriate uses of information, uses that avoid privacy harms, we look to things like broadly shared cultural norms. Would they like to have that information revealed about them to strangers? And we look to whether processing information affects vulnerable sets of people like gay teenagers. Even though not many gay teenagers run businesses, I try to ask my clients to put themselves in their shoes. And we also, my clients and we are aware of how large data sets create vulnerabilities. So look at Target Neiman Marcus breaches to underscore that. So once we inventory those privacy harms, businesses can be better equipped to take steps to reduce risks. And they do things like reduce the retention time limits on the information. They only keep it for as long as they need to. Or they engage in real de-identification, either technical de-identification or through rules. Or they impose contractual limits on their business partners about how this information is shared. But they only do that after they understand what the risks of having this information around might be, not just as a legal or regulatory matter, but, as I say, as a more general matter of harm. And so there is an opportunity, I think, going forward, and this is what our paper is going to be about, for a collective and transparent effort to try to come to some common understandings about what constitutes privacy harms, not just from the legal perspective, but what would society expect today to be harmful and how to avoid them. And so this conference is a great example of that kind of conversation. And as the ranks of privacy professional grows, I'll do a free ad for Omer and the International Association of Privacy Professionals. There's something like... Second free ad, right. Now, the first one was also my self-interest, since you're part of the Future Privacy Forum. But there are tens of thousands of privacy professionals, and the ranks are growing. And I think together we can do a better job of measuring and protecting against privacy harms by not just looking at the law, not proposing necessarily legal changes, but taking a holistic view to privacy harms. So thanks again for having me.
Okay, Okay, Adam and David are our discussants for these panelists. So Adam, you want to share your comments on them?
Sure. Well, good afternoon, everyone. Again, my name is Adam Thier. I'm a senior researcher at George Mason University in the Mercatus Center there. I've spent the last 22 years of my life covering technology policy, the last dozen of which covering safety, security, and privacy, and the intersection of those three areas of cyber law, because along with IP, those are really the four major fault lines of internet policy today. And I discuss in all my work sort of the common themes and the common challenges associated with efforts to enforce harms and rights in these contexts of safety, security, and privacy. I had a crazy year last year where I had 7 law review articles, 4 of which were just on privacy and 2 of which were just on this issue of trying to measure privacy harms and risks. And to the extent that there's a takeaway from my remarks and thinking about the papers presented here, it's that to the extent there's any sort of unified field theory of harm in the context of safety, security, or privacy, it really comes down to the old "I know it when I see it" standard. I hate to say it, but it's just the vast majority of asserted harms in these fields of safety, security, and privacy today are so radically subjective that they simply cannot be measured by any standardized metric. It's not to say that there aren't harms in each of these contexts. I certainly think we can identify, and we've heard some here today. It's just to say that it's damn hard. In fact, in one of my law review articles, one that I had in the Harvard Journal of Law and Public Policy, I likened it to trying to define happiness harms. We all would agree that happiness is an important part of human dignity, as is privacy and safety and security, but it doesn't make it any easier to define what harms our happiness in any other context. We also hear a lot about creepiness and annoyance and a general sense of unease and a lot of these other so-called subjective harms that Ryan discusses in some of his work. The problem is that those are such amorphous standards that they can't possibly be what we base our jurisprudence upon or our legal enforcement efforts. Or else really much of the digital economy as we know it will have to probably shut down if creepiness and annoyance or a general sense of unease is our standard. At least here in the United States, our sense of safety, security, and privacy rights, and privacy in particular, have always been tethered to some other unambiguous harm, usually some sort of tangible physical rights, rights in property, the body, the sanctity of the home, financial well-being, sometimes health-related information. My general point here is just this, that the further we move away from that standard that we've developed here in the U.S., the harder it will be to classify and measure harms. It's not to say it shouldn't be tried, it's just to say that it's going to become incredibly difficult. It will become incredibly difficult, secondly, because, and this builds on Fran Meyer's point in an earlier panel, norms and ethics change. And therefore, so too does our understanding of what constitutes a harm as it relates to safety, security, and privacy in our society. And more importantly, these norms and ethics are changing at an accelerated pace today relative to the past. Today, one person's creepy tool today can be their killer app tomorrow. You look at sort of the history of how Gmail unfolded, and initially there were lawsuits to stop Gmail, and in very short order, 425 million people were subscribing to that service and enjoying it. Facebook is, to some, the great privacy pariah of our time. To a billion other people, it's an essential social utility. This is a story that's played out throughout history. An earlier law review article this year, I talked about techno-panics throughout history, and I went back and talked about the camera and the role it played in the Brandeis and Warren paper, and how they were sitting there wringing their hands. What are we going to do about the camera? And in very short order, we gave them their answer. We're going to buy one. It became an essential technology that we all wanted to have access to. Again, there were still privacy harms associated with it, but again, we did assimilate it into our lives, I think, much more quickly than Brandeis and Warren would have believed. The bottom line is that social adaptation happens. And it's harder when the pace of technological disruption is moving as fast as it is today to cope and to adjust our norms, but it's something that does happen. A third quick point that I think has bearing on this question of measuring risk is that information control writ large is only getting more complicated and more expensive, and we need to be aware of the potential sort of counter harms or costs that arise out of attempts to try to protect safety, security, and privacy. The reality is that once information gets out there, it's damn hard to bottle up. And we have found out in the safety context, whether we try to have mandatory filtering, centralized efforts, whether it's in copyright context, something like SOPA, or even in privacy with something like the Europeans are considering with the right to be forgotten, I mean, these are attempts to really exert sort of strong information control, even potentially attacking the very underlying architecture of the internet and networks to try to remedy this problem. But generally speaking, they're not going to work, and attempts to try to do them are going to have enormous costs, both social and economic. I mean, attempts to have sweeping privacy restrictions, as many scholars have pointed out in past research, could have other types of harms. It could have harms on freedom of speech and expression, harms on information gathering by journalists and historians, and a variety of other types of things like that that would lead to a more transparent society. There are also economic harms. We should not discount, and have not discussed here enough today, the potential costs associated with privacy controls and the harms that could come to innovation and to consumer welfare and to marketplace competition and market structure and innovation. These are things that consumers care about too. They deserve to be taken into account when we talk about these other harms. So we have to keep that in mind. And then the fourth and final point I'll make is that if it's true that information control is costly and becoming more costly and harder than ever, and if it's also true that these harms that we're discussing are as radically subjective as I've suggested that they are, sometimes even undefinable, I would argue, and I've argued in my recent work, that we need to consider alternative approaches. We need to consider alternative remedies that potentially are a better use of our scarce societal resources and energy. We need to consider diverse approaches for a diverse citizenry, since we can't all even agree on what constitutes harm in a lot of these contexts. I think the most fruitful way to go is an educational-based path of digital citizenship, media literacy, digital ethics training, talking to our children, talking to our developers about instilling smart lessons, smart ethics. It begins at a very young age, but can continue at every age after that. We've gotten to that point in the online safety battles, I would argue. There were 6 online safety task forces that met since 1999. I was on 3 of them, and every one of them came to the same conclusion, which is the top-down approaches, generally speaking, probably are not going to work. We need to consider the sort of bottom-up approaches, usually rooted in education, empowerment, ethics, digital citizenship, media literacy, to try to change individual and societal attitudes about how to respect each other, respect each other's information, respect each other's safety and security. This isn't a cure-all. It's not a silver bullet. And enforcement has to be part of this story, too. We absolutely need to make that part of the deal. That's why I always sometimes talk about, in my work, a corny phrase, the 3E approach of education, empowerment, and targeted enforcement as being the ultimate solution here, but really in that order. And I think ultimately our conversation of harms has to take into account these other factors that I've discussed here today, and then reconsider if there's a better set of remedies to approach these issues. Thank you.
Okay, I want to break all the rules really fast and let Ryan ask some pointed questions to you, Adam, if you can respond very briefly.
Respondent to a respondent?
Yes.
Sorry, yeah, exactly. So, I mean, I don't know. So there's a seductive aspect to a lot of what you're saying, right? And I just want to clarify what the counter-arguments are, because I'm worried that some of you are seduced. Are any of you seduced?
I'm a little seduced. Yeah.
Brian, this is the marketplace of ideas. They get to choose.
Yeah, so it was seductive, but I just want to complicate matters. You can vouch for that.
Especially in the picture.
So a couple different things. One, this idea that harms are too subjective. They're too subjective. I mean, what's a happiness harm? I'm not really sure. What's a fear harm? Right? What's a fear harm? Yet we've had hundreds of years of assault as a tort in the common law. The first assault case, one of the first assault cases, was where an innkeeper was like leaning out of her window, and she was just telling somebody, "You can't come in, you're too drunk," and he threw an axe at her head. And the axe actually missed her and hit right next to her. And it wasn't technically a battery, right? But the court was sitting there thinking to itself, gosh, that's not all right. You know what I mean? Let's do something. Axe in someone's head. But they actually sat there and they were like really wringing their hands the way that Adam is today. And they're saying, but what's the limiting principle if we open it up to this? But hey, we've muddled through, right? We've muddled through it. So that's one point, is that there are really hard lines to draw all throughout the law, not just privacy, number one. And the number two thing I want to say really quickly is, you got to ask yourself, are we better off? Like that's, I mean, I as a scholar have to admit, I don't actually do that enough. I don't step back and ask myself and say, are we better off? So like, the idea is that we've adopted, a billion of us adopted Facebook, and we've sort of inexorably moved forward and evolved in innovation and so forth. But I think real serious people like Julie Cohen and Frank Pasquale are asking ourselves, are we better off? Why is depression skyrocketing? Why is income inequality skyrocketing? Right? are we better off? And so the idea that like a lot of people get to use Fitbit now, like is important, right? But I mean, think about it against the greater societal and cultural context as you process the, I think, otherwise very seductive.
You want to ban Fitbit now, Ryan? I lost 30 pounds with my Fitbit. I give it up easily.
And he looks
Is
great in
society
his
better
picture.
off? I'm 30 pounds better off.
You look great. That's the problem. That's why I felt the need to interview you.
It's very so seductive.
So second point, really quick first. The second point, I mean, are we better off? Well, I don't know, but I don't necessarily want a handful of people in the ivory tower deciding for all of society if we're better off. I'd like that to be an evolutionary process that we discuss over time. We will have to have rules at the margins where serious harms exist. But generally speaking, are we better off because of Fitbit or because of Facebook? Well, finish your thought. What? Or we ban them? We stop that sort of permissionless innovation from going forward? I say no. I say we have it, we see if actual harms develop, and then we go forward. Back to your first point, an axe being thrown at somebody's head is an attempt at a physical assault. We can draw a line there, right? That's a little bit different than saying, ooh, it's creepy that there's people walking on the street I don't like, or, I think that guy might assault me. No, that's not the same thing. An axe being, we can draw a line there, right?
Well, I think we can all agree that our problems are better now than they were in the axe throwing
Yeah.
time.
They're tougher. I mean, imagine if I was teaching, I teach torts, so imagine I go into torts and I'm just like, okay, so assault, this is axe, it throws a head, that's messed up, right? Okay, let's move on. No, there's been many cases trying to figure out exactly, there's also like a whole bunch of emotional harm cases.
Yeah,
and
Devin and I are
emotional
feeling a
harm.
little exposed here.
Yeah, exactly. So anyway,
guys
I'm going to back
are-
over.
yeah, yeah.
Thank you for the ability to, and thanks for your
Sure.
good response, Adam.
David, can we get your thoughts on these panelists?
Not on that.
All right.
So I'm David Zatuni. I head Brian Cave's data privacy and security practice. My perspective is a little bit different, and I think really fits in nicely with this forum. I'm glad it was organized because it does have the academic focus, it has the private sector focus, and a lot of times those two aren't aligned. And so I want to give a little bit of perspective in terms of measuring harm from the private sector side. When my clients go through the analysis of looking at privacy and data security, what are they focused on? And it's a little different than what I think all of us in the room are focused on when we think academically of privacy and security. And a lot of it comes down to what the economists have been saying today. And Ryan, you actually said at the beginning of your piece, which is companies are rational actors. They are pushed from economic trends. Most companies are also not market makers. I mean, there's 1% of companies, the Google, the Facebook, which are innovating in a privacy way. Most companies are market takers. They're using technology because technology is available and because their competitors are using technology. So when they're doing a risk analysis and when they're thinking about measuring harm, what is really important for them is trying to really quantify it. Measuring really means measuring because everything in the corporate world eventually is quantified. Sales are quantified. Risk is quantified. How much it costs to do compliance programs is quantified. And so for them to have something useful, it really comes down to how do we physically measure the harm for all of the issues that we're talking about. And how they approach it is, I think, different from how academics might approach it. So for companies, they look at what are the risks to the company on the privacy and the data security side. And looking just at privacy, we'll put security to the side. You can look at class action risks. You can look at the risk of an FTC investigation. You can look at the risk of regulatory investigations or other legislative changes. And those can be quantified. One thing that we do every quarter is we publish a report on all of the data privacy and security class actions. And we look for the trends. And those trends really indicate where the corporate risks are, where people are getting sued, what courts are doing with that. And that doesn't line up necessarily with what I think any of the panelists would say are the real privacy risks. And for example, if you look at different types of data fields, think name, think telephone number, email address, date of birth, social security number, sexual orientation, healthcare data, which of those is the most sensitive? And we probably would all have maybe a slightly different opinion, but some of us might say healthcare data, some of us might say date of birth or social security, some might say something like geolocation. From a corporate perspective, if you do a risk analysis in an objective way, 50% of all of the data privacy and security class actions now are under the TCPA, the Telephone Consumer Protection Act, and they are suing on using people's mobile telephone numbers. So if you were thinking from a corporate standpoint of what is the biggest threat to my company on a data privacy perspective, it's not whether or not you're going to share geolocation. It's not whether or not you're going to share healthcare data. It's whether or not you're going to be using people's mobile telephone numbers to send them a text message saying you get 25% off. That, and I'll give you an example. There's a company, imagine a company that sent a million text messages out, which sounds like a lot, but it's actually not a lot in the marketing space. Under the TCPA, the potential exposure to that company is about $500 million, all right? Now, we all saw the FTC's announcement of recent cases against very big tech companies, and sometimes they're able to get redress and restitution. There is no case which approaches that amount. So when you start thinking from a company perspective, they are takers of the law as it is. They are takers a lot of times about where the law has set out the risks and the liabilities, and how that lines up, I think, is very different from an academic perspective. I think that's something that a lot of attention needs to be paid at in terms of realigning the structure of where the statutes assign liability and where we as a society from a legal perspective are telling the companies on the statutory side what is most important, which doesn't line up necessarily with what I think all the panelists here would probably tell companies is most important. And to try to resolve that as a company, you have to pay attention to, on some level, the bottom line. You have to pay attention to the class action bar, and you have to pay attention to the people who are going to come after you. Even though you are also focused on the softer issues of privacy, at the end of the day, that really does sometimes take the forefront.
Could I just comment on that? I would think that the CEO of Target, even before the first class action was filed, and there have probably been dozens filed since the news of their breach came out, understood that people were leaving the store in droves. Apparently their December numbers and their early January numbers were really awful because of the reputational hit.
Yeah, absolutely. Well, and that's why I said privacy versus security. I prefaced all my remarks, but I'm going to focus on privacy risk, not security risk.
Yeah, but
security is different because you really
I think they're really related, frankly. I think if the news had come out that Target had used personal information in a really, creepy way, and it had caught the attention of a Julia Angwin or somebody else in newspapers, I think in the current environment, that could really affect the bottom line, could affect the stock price.
Although that's actually a really good analogy, because something did come out about Target using data in a very creepy way, right, 2 years ago or a year and a half ago about their predictive behavioral advertising.
Pretty esoteric, though. I'm talking about something really creepy.
Well, I don't know. Our moderator might disagree with you in terms of whether she thinks that's creepy or not. I kind of think Target, if it is true that they predicted teenagers getting pregnant and necessarily alerting their parents to that, that's kind of creepy. But the point here being, again, and I think they do pay attention to that. I think they absolutely do. But in terms of quantifying and measuring and assessing, and if we're talking about assessments, that is high on the list. It will always be high on the list. And as you know, your clients pay attention to that. My clients pay attention to that. But when it comes to prioritization and when it comes to ranking these things out, there is a major disalignment between what our current legal statutory structure penalizes companies for, and I think what most in the privacy world think they should be penalized for. And I think, Chris, I think you alluded to this too.
Yeah.
Technical violations and privacy policies. Plaintiffs love that, right? And as you were saying, that really is not a privacy harm. And I would agree with that. It's not a privacy harm.
Not always a privacy.
Not always a harm, always a harm. But that can be very destructive to a company in a way that other actions which might actually be privacy harms might not be legally destructive. Might be reputationally destructive, but not legally destructive.
All right, thanks, guys. I have questions now. So I wanted to do something a little different with the Q&A. I wanted to do a big question and then a quick fire question, a big question and quick fire question. But since we're running out of time, I'm going to go quick fire, big question, quick fire. And the first one is actually very related to what David just said. True or false? If you can't measure it, you can't manage it. Yeah, you.
Oh, yeah, okay. You can't measure it, you can't manage it.
You can substitute, if you can't measure it, you can't govern it. Is this a true statement?
I think that's basically false.
Okay.
I'm going to say it's true, but that's only if you're open to some more creative ways to measure.
Okay.
Is this Family Feud? We're going to see what...
There's prizes at the end.
Richard Dawson's going to kiss us at the
Yeah. So I would say it's false for the reasons that I said. I think you can be sensitive to privacy harms without necessarily being able to get your fingers on it in a tangible way.
Yeah, I would agree with that. False.
Can I have a sentence response? I'm going to say false,
How come I
but
accidentally said true?
But I'm actually going to start with Devin on this. I think there are creative ways to measure it, and if you can measure it, you can do a heck of a lot better at managing it. And I think one thing that companies are discovering now is there are areas of privacy that they thought were not measurable, And there are ways to measure it. They may not be the most perfect ways, but there are ways to measure it that can help them manage it.
It seems a little paradoxical to me that a company can know when I'm pregnant, but it can't know when it's creeped me out. I mean, if they have enough data, shouldn't they have some sense of when they're pushing my bounds, if they know where my hormone levels
Bring
are?
up a really, you bring up a really great point, because I suspect the marketing people who thought that was a really great idea to do that data analytics and to send out the
Throw more
flyers
data at the problem.
were not at the top ranks of the corporation, because the privacy issue then, they are now, were not in the boardroom, were not in the C-suite. And so I think it's an issue of corporate structure. Who's paying attention to the privacy issues? And it's really fun as a privacy lawyer now to be able to go up the ranks in the corporation, actually brief a board and talk to the CEO, because it's now an issue they're concerned about. And they build in a review structure that didn't exist, obviously, when something like that happens.
But the answer really, Meg, is that no, they can't, because there's a lot of other women who may actually invite that sort of personalization and the potential benefit of reduced prices on baby-related stuff. And in their databases, it's not yet, they don't have that ability to differentiate. Like, this expecting mother might think it's creepy. This one would love the benefits of the price reduction. Again, it's not enough shared values on that point, right? Now, maybe you could signal to them, like, please don't send me any more, and then they'd have that indication in their database.
Well, I feel like they should be able to figure it out. They know me so well.
Maybe, maybe not. But isn't the more amazing thing about the Target story how few women came forward? That's what amazed me.
Well, probably, yeah. I don't think I would have noticed. I get so many coupons.
But after it came out.
So there's also something ironic here. People who do data privacy are not the most data sophisticated. So, marketing departments, they're used to using data. The people who sell data to marketing departments and analyze it are very sophisticated. There's a whole industry behind it. But for the legal department, lawyers, and even for privacy professionals, the degree to which they are doing data analytics in terms of answering the questions that we care about, I think is leagues behind what the marketing side is doing. And part of it is just, I think, the backgrounds that we come at. I mean, lawyers are not trained to be data miners. And law professors or other academics aren't necessarily trained unless you're on the economic side or one of those other crossovers. But I think that needs to change. I think if you start bringing the same tools that the data miners are doing on the marketing side to the legal compliance side, then you have more power. There's more ability for companies to start looking at those things.
That sets up what's going to be my last question before I turn it over to the audience, which is about I guess measuring creepy, and this idea that a data controller has some new data practice that they're going to put into the field. And Chris, you kind of mentioned that one of the things they do is they ask each other, would this creep you out? And it's kind of this gut check that they're doing internally. But it's hard to make people accountable for a gut check response to a data practice. Is there a more Is there more of a risk assessment model that we could develop that's based, should we be bringing in social scientists to answer these questions as opposed to the practitioner's gut response to whether a practice is over a line or not?
So I think the large majority of the decisions are not that close. And so you're really talking about a small subset that fall into the creepiness category. And there, I think you have to have a lot of inputs from people throughout the company. And if you need to bring in an outside expert, that's great too. One of the examples that I think of, and that's how we got a hotel company as a client, is they thought providing personal service was what hotels were all about. And so this couple was checking into a hotel in New York City, and the desk clerk said, Mr. and Ms. Smith, welcome to our hotel. Oh, Mr. Smith, we see you stayed in our Dallas hotel earlier this week. We hope you had a nice stay. And the wife said, honey, we live in Dallas. Why would you be staying in a hotel? They thought that was great customer service. And obviously, the marketing department didn't think very much about that particular scenario. So
sometimes you do have to ask someone, right?
Yeah.
Devin brought up the notion of having to be channeled into institutional review boards, right, under certain circumstances. Yeah. And Paul and I have been talking about this a little bit too. I wrote this paper I wrote an online essay for a Stanford Law Review Online recently in connection to its big data program about what would it look like to have, a kind of a formal gut check, let's say, but a kind of institutional review board within a corporation, right? I mean, it's sort of strange how corporations are able to treat. By the way, I'm coming off like totally different than usual, but anyway, it's sort of strange how corporations are able to treat, you know, consumers essentially like guinea pigs in order to sort of figure out what works and what doesn't, and there is no institutional structure in place. I mean, there are even laws about researching, like if I were to research on guinea pigs, I would have to actually go through certain laws, actual guinea pigs. I'd have to go through certain laws, you know what I mean? Whereas they're able to sort of, and so for example, you know, the idea that when I first started going to the movies and there was ads at the beginning of it, I remember sitting there and thinking to myself, like, I can't believe I'm watching ads for 12 minutes. You know what I mean? After I just paid $9 or whatever it was, and I was just about to get up from my seat and complain when the movie started. Actually, the preview started. It wasn't even the movie, right? And then when I did a little more digging, it turned out that actually, like, they did like experimental studies on people to figure out just how long you'd sit there before you complain, right? And so, like, I want someone to check a box on that, maybe, right, and to make sure. And so I feel like one way to change incentives, and I really do believe that, like, we should have, you know, different ideas for different kinds of people, and I think corporations are not the same thing as governments. But I do think that with respect to corporations, changing incentives in a structured way might be helpful.
But you know, a lot of companies are bringing in consumer advocates and outsiders when they're rolling out something. And a lot of companies go to the FTC and say, before we do this, what do you think of this?
We also have to be willing to change our perceptions on the ivory tower side about what is creepy. And I'll give you an example. During panel 2, one of the panelists was saying that facial recognition software is one of the big, possibly creepy factors coming forward. So as you guys probably are aware, many people are aware, there were a lot of newspaper articles about facial recognition software this year. It was in the New York Times and the Wall Street Journal. I think at one point in time we ran a search, I think it was hundreds of little articles about how retailers were using facial technology or could be using it so that when you walked into a store, it would know who you are and it could do behavioral advertising to you. Well, if you look in Consumer Sentinel, which is the FTC's database of consumer complaints that is supposed to aggregate complaints given to a variety of government agencies on things like privacy and data security, there were 0 complaints against any of those companies that were named in those newspaper articles. After 100 articles or so had been published in places like the New York Times and the Wall Street Journal, which were naming all kinds of names in terms of companies. And so there's a disconnect there. If the public is informed in such a broadcast way from the policy privacy journalist side of something they find creepy, and there were no complaints from anybody on the consumer side in terms of the practice, even after this had been vetted on TV, it should cause us to step back and wonder, do consumers actually care about that practice?
Of course, you're assuming consumers read newspapers and watch TV.
Well, that's true. There were tweets.
Know that they're
There were
supposed to
tweets on
file
this
things
issue.
at the FTC if they're concerned about it. Adam, did you
Very
have something
small
quick?
point.
Okay.
I want to endorse Ryan's idea of greater internal review boards or efforts in terms of, you know, privacy. This is part of privacy by design, right, and security by design. A lot of companies already do this, but at the end of the day, there are going to be some limits to this process. And there's no experiment or there's no review process like getting a product to market and seeing if consumers actually like it or not. So at the end of the day, if we want the permissionless innovation ethos that's powered the internet so far to continue, we have to understand that companies are going to put products and services on the market that sometimes make mistakes and people, you know, have a reaction to. But there's going to be a lot of other products where like, oh, that shouldn't have passed the line, and people embrace it and love it.
Well,
So you don't know all these things preemptively.
but that assumes that the users of the products are aware of the creepiness aspect to it, which is not always true.
Okay, let's turn to the audience. I don't know where our microphone is. There she is. Students. Students have to go first. Yeah, right here? Yes, no, you. You're turning around, but I mean you.
So this wouldn't really be Colorado if I didn't ask this, but as medical marijuana and everything else has sort of become out there, where literally even your name being known or found can be a huge deal, but at the same time, you have that federal disconnect between state law and everything else. How do you kind of draw the line for like what you collect for privacy or how secure you make it when you turn it over? Like how does that all kind of work together when you have such a unique industry like it is right now?
So I love tying marijuana to privacy. I've not
What we do
thought of
here.
that. Can you tweet that so you can? No, but it's a great question because we do see the states legislating in ways that the feds have not. And California in particular has become the highest common denominator because it's a huge economy. And so many of the companies that operate on the internet especially sell into California, and they have to comply with California law. So California has become essentially a federal regulator or lawmaker. So maybe we could argue that Colorado's marijuana law applies nationwide. No, that probably doesn't work.
Nice try.
Other questions right in front here?
For Adam, I want to camp on something that you said. In my former life, I was a safety engineer. So, you know, safety engineers were kind of nuts about root cause analysis. How did this problem start? And it seems to me that a lot of what we've been dealing with here today is the effect, not the cause. It seems that the sort of the root cause is that individuals don't have any control over the acquisition and use of their data. You made a great example, Mr. Wolf, when you said about the guy in the hotel in Dallas. Somebody else had his data, and they made the decision for how they were going to use it. Same thing with Target and sending out the pregnancy coupons. So my question is if you can't deal, if you don't deal technologically with the issue of being able to control my data, how much real progress are you going to make in solving this problem?
So I wrote a column for the IAPP blog about this, about should we give up on the idea of contracting around privacy, and is there a way to better secure or propertize our personal information? I know you mentioned your company's efforts. There are others, Reputation.com, Personal, many others are in the data vault business. I have not yet given up hope entirely that contractual marketplace can exist around data privacy rights. I just think it's really damn hard, and I want to see the proof of concept go to market and actually work. But the problem gets back to the same information control I identified earlier, which is, say you secure it for a customer, and he lets it out, or a friend or colleague lets out a personal piece of information somewhere else. You can't control all of these possible uses.
You can't control all of it, but you can give people much more choice over what, and visibility into what's being done.
I agree. I hope it works. I hope it works. Look at the paper that Hal Varian wrote in '97 on this, and Ellie Noem wrote about this as well in '98. I mean, there are theoretical approaches to this out there in the literature, and now it looks like there's some companies actually trying to produce. Good luck.
One more question.
She's good with that microphone.
I know, she's hot.
You're on.
Just to follow up to David, your comment on facial recognition. Isn't what you're talking about in terms of the database not having any complaints really a problem about in-store notice? Because I read like half of those stories, and the problem is that the names of the companies disclosed in those stories are separate from the names of the retailers where that technology is being used, and so people don't know if it was used on them. Now, importantly, to your credit, what's going on in stores mostly is face categorization rather than face identification, which is less creepy. But have you considered that, and what do you think about that?
Yeah, and let me clarify. My comment is that I think we need to start looking at these disparities so that we raise the question. And I'm not coming out either side saying it's creepy or not creepy or this proves or doesn't prove, but I think it does raise an interesting question. I know a lot of those, there were two main retailers who were identified in a lot of those articles. And if you read through all the articles, which I did at one point in time, it got to like about 20 retailers. Some were very small, some were very large. And I have not gone back. It's difficult to go back and do the type of analysis on Consumer Sentinel unless you're at the FTC. It's something that I think and I hope will change, because I think that type of data and other sources like that have great academic use, that I think questions like this should be done so that people, academics, can probe into these questions and say, when something comes out in the press, what is the consumer response to that? What should be the expected rate? What is the baseline? I mean, if we believe that when there's a privacy-oriented article, the baseline is, you may get 1% of the users who file complaints, but then you see a privacy-oriented issue that hits the media space and it jumps up to 20 or 25%, that to me would be a huge red flag that this is something consumers care about. Versus if the baseline is 1% and it's 1% or 2%, you'd say that's just the baseline. That's normal people complaining about random things, and that doesn't really indicate a privacy issue that the consumers are trying to elevate to the government. So I think my comment really, the intent of it was, I think there is data out there that is not being tapped, and if it were tapped, it would spark more discussions. And it would spark areas where we could do further investigation and have further comments about what is this, besides just saying it feels wrong to me, does it feel wrong to you? We could have a little bit more of a quantitative type of discussion.
Well, we're going to take a 15-minute break, so now please give all of our panelists a round of applause.